Hello and welcome everyone to Immigration and Jobs Talk Show. And I'm very excited to be here on another episode. Thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and Twitter. So I'm very happy to have you. Thank you so much. And there's this important disclaimer before we move ahead with today's episode. So, the disclaimer is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, friends, thank you so much for joining us here on Immigration and Jobs Talk Show. This is where we bring you expert advice and practical strategies to navigate and dive into the complexities of visas, and we are mostly helped with on this by our guests who join us, who help us dive deep into every topic in each discussion. And today as well, it's going to be the same. So thank you so much. I'm going to be your host. I'm Nipasa Pradhan, and today's topic is, by the way, about H-1B RFEs, what triggers them, and how can you successfully respond to these RFEs. So to help us, dive deeper into the H-1B RFEs and maybe help understand better, we've got our very regular guest who makes it a point to join us every Wednesday at 12 p.m. Eastern Time. So thank you so much, Prashanti, for joining us today once again. Really happy to have you. How are you doing today?
I'm great. How are you, Nipasa?
I'm doing much better. Thank you so much, Prashanti, and I'm excited for today's discussion.
Absolutely.
So, H-1B fees. What can folks out there expect? Of course, from apart from the obvious, if there's anything that you would like to highlight in today's webinar, Prashanti.
I guess we'll talk about, in general, what kind of how to avoid a H-1B RFE because that's the whole goal. We don't want to get an RFE, but
Yes.
sometimes it's unavoidable. So when we get it, what are the likely issues that come up in an RFE and how to maybe respond to them?
Mhm.
Also, what might change with the new administration coming in with reference to H1s, what RFEs to expect. Um, that's a few things we'll be covering.
Absolutely, absolutely. And whenever we hear request for evidence or an RFE, it's pretty nerve-wracking. And I think it just makes people so anxious, whether it's USCIS flagging your petition or what do they want to see? What do they want to know? How do we prove that? There's so many things. And today we're going to discuss all of that, friends. So please feel free to comment whatever questions you have regarding H-1B RFEs. We'll be very happy to address them today in the show. So, thank you so much for joining. And I think with this, we can move ahead. And plus, we can't ignore the ripple effects of the leadership that this new administration has, especially with names like Tom Homan being afloated for pivoted roles. And I'm sure like this could mean a big thing for immigration, and these policies are going to impact H-1Bs as well. So, Prashanti, anything you want to say on that too?
I think let's discuss that once we discuss what's happening presently, and then
Sure.
we'll go to what the ripple effect might be, so people get a better understanding of what RFE is first of all, and then we can talk about how that
Right.
might change under Trump.
Okay, let's go ahead with it then. First off, what is an RFE, and what are the most common triggers for H-1B RFEs, and how can employers and applicants prepare to address these RFEs effectively during the cap season?
So, an RFE is nothing but a request for further evidence. So, when you file a H-1B petition or any other petition for that matter with USCIS, there might be some more information that they need. So, they call it a request for further evidence. It's something that's sent in the mail. And nowadays, with online filing, you can get those RFEs online as well. So, it's just a document that is telling you. Why what document is needed or what explanation is needed so that your H1 can get approved or become whole, right? So that's a request for further evidence. Usually, um, there is a certain timeline, 84 days within which you have to respond. And you have to respond at one time, and you have to respond before the deadline, obviously. Otherwise, your case will get denied. So that's an RFE. And the notice also will tell you which address to respond on as well. So it'll have all that information in there. So I think the most common RFEs, let's just go through some of the RFEs that we usually get. And the reason to go through them is so that we can avoid getting them. If we prepare our application properly, we can avoid getting RFEs. If we can, if we already if we know what to expect, then we can avoid it by giving them that information beforehand, right? So one of the most important RFEs, and they always ask this, it's the very basis on which a H-1B is filed. It is specialty occupation. So the very basis for getting a H1 is that the job should be a specialty occupation. What's a specialty occupation? A job which requires a bachelor's degree in a specific field. So failure to establish that the position qualifies as a specialty occupation can lead to an RFE. And no matter which administration comes in, how liberal or how strict they are, this is always has always been a reason to get an RFE. So if you file a H1 with a job title, which perhaps USCIS may not be familiar with, or maybe it's a combination of jobs that the person is doing, and more importantly, if it's not listed in the Occupational Outlook Handbook, um, that which is the Labor Department website, which USCIS goes to see whether something is a specialty occupation or not. In that handbook, which is also available online, they list many thousands of jobs, and they also put in what that job requirement is. So if in that job requirement it says a bachelor's degree in a specific field is required, then usually USCIS will not send out an RFE for specialty occupation. But sometimes they may, if the duties don't look like, don't coincide with what the job is. If the duties look different from the job title, for example. Say you have a job title of a software developer, but you're putting the duties of a computer programmer, testing, coding, etc., and not design and develop. Then, they might send an RFE for specialty occupation saying the duties don't seem to be that of a software developer. So, software developer, as I said, is always their favorite RFE. So, when you're doing the H1, make sure you put a description which matches the job title. Use a job title that they're familiar with, or if you're using a job title which is not in the OH or they're not familiar with, make sure you list the duties in such a manner that it becomes clear to USCIS that it's so complex that a bachelor's degree is required. Even if you have to give an explanation in your petitioner letter that this is why a bachelor's degree is required, go ahead and do it. Preempt, the specialty occupation RFE. So that's something that is always there, and USCIS, of course, keeps changing this interpretation of what is a specialty occupation depending on which administration comes in. So USCIS has significantly narrowed what qualifies as a specialty occupation, and they're often challenging positions with job duties that don't appear complex enough to require a bachelor's degree. So as I was saying, that's why it's very important to put in a job description there and put in a proper job description. Uh, and in the past, USCIS has said under the Trump administration and even under the, Democratic administrations as well, that they've narrowed it down, saying that degree since the job requires a bachelor's degree in computer science or engineering, it's not a specific degree, so it's not a specialty occupation. So they've gone beyond what the regulation says, and they've interpreted it in a more stricter manner, and they've denied cases on specialty occupation based on that as well. Market research analyst is a position which has received a lot of attention over the years because of USCIS denials. Because the OH says that the market research analyst requires a bachelor's degree in marketing or in economics, or so there's different related fields, and they're saying that, because it's more than one field, it's not a specialty occupation. So that's one. The other RFE that you could possibly get is for availability of work, though that has decreased now, but we're still getting some form of asking. They're asking this in some way or the other, especially if you are a consulting company. Um, they issue RFEs for people working at third-party sites. They want to make sure that it's not speculative employment, that you actually have work. But again, they're not been asking for client letters recently, but they might come back to it under the Trump administration. They may come back to it. There's also a pending regulation, which where they're codifying it, and they're saying that based on the regulation, they will be able to ask for it moving forward. So right now they're not, but there is sometimes, if they might ask for might ask this more indirectly by asking what type of business you are doing business, so they might ask for, the nature of business, and how much business do you do, and just for this, so that they can figure out whether you actually need the employee the way you're saying you need that employee. So again, this is to because there is something in the regulation which says employment cannot be speculative. So that's why they want to make sure that you have availability of work. But they're not asking for documents such as client letters, which like they used to before. They used to ask for contracts, purchase orders, vendor letters, client letters, everything, you name it. Um, and they wanted to see that you have those contracts for the entire duration of the H1. So they've become much more liberal now, but I think this is only for a short period of time. This is going to change very soon. The other RFE that they send is often for beneficiaries' qualifications, and part of this is asking for an evaluation. So evaluation is very common now. Most cases, if you don't do an evaluation, even though it's a straightforward degree, if it's a foreign degree, even though you might have a computer science engineering degree from India, they are asking for evaluations. So my suggestion to you is get an evaluation done, especially if you're in a rush to get your H1 approved, because you are more likely to get an RFE for evaluations. I'm seeing a lot of these RFEs now. So they'll ask you for either to prove how the degree is related, or they'll ask you to get an evaluation done, an expert opinion letter showing how the degree is related, and the degree is equivalent to a US bachelor's degree in computer science. And if you're not able to show that the person has a related degree, say you are filing it as a software engineer, but the person has a degree in mathematics, but has 3 years of experience in computer science, then you can get a work experience evaluation done. So they will send an RFE if you don't get that done beforehand. You don't submit experience letters. They want to see a correlation obviously, between the degree and the job that is being done. Maintenance of status is another RFE that they send out if they think that you haven't maintained status, especially if you're filing a H1 extension, or transfer or amendment. If you don't submit your latest pay stubs, they are definitely going to ask for that as part of the maintenance of status section of the RFE. Uh, Also, they might ask for proof that you have maintained status throughout your previous 3 years of being on a H1. So they might ask for I-797 approvals, I-94s to make sure that they've never expired, and that you've always maintained status. Pay stubs, W-2s, tax returns, um, all the H1 approvals. They want to make sure that you're getting paid as per the prevailing wage, so they're going to check into that as maintenance of status. They want to make sure that you're working at the LCA work site. So they're going to look into that to make sure that you are. So these are some of the issues that you might come across with reference to maintenance of status. Also, when you're filing an LCA, you have to make sure that the labor condition application, which is, a preliminary document that you get approved from the Labor Department before you actually file a H1. So they want to make sure that that document corresponds with the rest of your documentation, your rest of your H-1B forms, etc. If it doesn't, you will get an RFE and you will get a denial because you cannot file a new LCA at that point. There's no way of correcting it. So always make sure that your LCA information corresponds with your I-129 information. Extremely important because you cannot correct it later on. And last but not the least is, you have only 6 years on your H1. If you're applying for a H1 beyond 6 years, or if they think that you have been on a H1 for more than 6 years, then they can send an RFE for the 6 year limit, and then they can ask you for how long you're in the country, when you traveled, so all your travel history and all your H1B approvals for the last 6 years, etc. So that is also an RFE that we receive. And also another RFE that we receive is for fee, because there's different fees depending on the size of the company, depending on whether it's an extension or an amendment. So sometimes if they think that you've paid the wrong fee, they will send an RFE saying that, we don't think you're exempt from paying the fee, or you're paying the lesser fee. Um, they'll ask for how many employees do you have. If you're saying you're exempt based on number of employees, then you have to submit proof that you have that number of employees. So this is a few, an overall view of what kind of H1s RFEs you might receive.
Thank you so much, Prashanti. That was very much detailed, and thank you for highlighting all these different types of RFEs that one can get in an H-1B visa. So, yes, at this moment, I would also like to just quickly say hello to our viewers who have commented with their questions. Pratibha and Anjali, thank you for your questions. Please stay with us. We will address your questions a little later in our webinar today. So, thank you, Prashanti, for that detailed explanation on what is an H-1B RFE and the different types of RFEs. Now, moving on, I have this next question, and that is, how has the scrutiny on H-1B petitions changed in recent years, particularly under shifting administrations right now, and what strategies can applicants adopt to ensure compliance?
So as I said, you have to be aware of what the laws are. And because even within the same administration, you often see shifts in the way USCIS is looking at cases, and how they're approving cases and what they're looking at. So, first thing is you have to be aware of what USCIS is expecting and how they're reviewing cases at that particular time, right? So, for example, with reference to specialty occupation, we've seen shifts in the sense that we've seen that they have changed the definition of what a specialty occupation is. So they have said over the years that a specialty occupation, under the Trump government, and even before that, under the Obama administration as well, they have said that it's not a specialty occupation if the job requires a bachelor's degree in more than one field. And there was litigation, and there's pushback on that because that's not what the regulation says. As long as you require a bachelor's degree, and even if it's more than one major, if the majors are related, then it is still a specific specialty, meaning it is still a specific degree requirement. That's why if anyone requires a bachelor's degree in BBA or an MBA or engineering and doesn't specify what field of business administration or what field of engineering, then that definitely becomes an issue. And so then we will get an RFE in that situation. But they've been trying to tweak that over the years. Not only that, also with reference to availability of work, they've changed. Right now, they're very liberal. They're not asking for client letters, etc. But the previous administration, as I said, not only were they asking for client letters, they were asking for all the parties involved. There's three parties involved. They wanted letters from everyone. They wanted the chain of contracts and POs. They wanted to make sure that the contracts were for the duration of the H1. So they had become very strict, and they were of the contract. So if the contract was, they were only giving approvals for 3 months. Now they've changed that after the ITSER versus Cessna decision in 2020. They've issued a new memo, and based on that, they're not really asking for any contracts. But if you submit them, of course, they will look at it and they will might send an RFE based on that. And at the consulate as well, they were asking much longer than USCIS. USCIS had stopped asking, but the consulates were still asking for client letters. And if you submit them, they are going back to the employer, going back to the client, and making sure that these contracts are genuine and there's still availability of work. They haven't expired. So we are seeing those shifts as well with reference to availability of work. And also, I think recently I think the RFEs that we're getting is more related to evaluations, one, and also change of status, maintenance of status, especially if you're filing a change of status from an F1 to a H1. They want to see if the student is maintaining a full course of study. They want proof of that, like they want the whole entire curriculum of the student, copies of the degrees. They want to make sure that you're attending classes in person. So all these kind of documents is what they're asking for. And the other RFE that we're getting is employer information, evidence regarding the organization. And they've been asking, since they're not asking for contracts and in-client letters, this is what they've been asking for instead. They're asking for proof that the business exists. They're asking for tax returns, organization chart, copy of the lease to show that you have an office address, the floor plan, letters from your neighbors to show that you actually have an office in place, um, and telephone bills, utility bills. So they're asking for everything related to whether the company actually exists or not. So that's a few, those are a few changes that have happened and what they're asking recently and what they asked over the years.
Well, thank you so much, Prashanti, for that detailed explanation. And absolutely, I mean, you're right. There's so much change coming ahead, and we wouldn't have understood before we understand what an RFE is and what could make you get an RFE. So I hope that we will prepare ourselves to not get our H-1B RFEs. And Prashanti, maybe you could give us a few tips also as we go to the next question. My next question is: imagine an H-1B applicant receives an RFE questioning the job's requirement for a bachelor's degree. How should they and their employer respond to prove the role's specialized nature?
So this is again the specialty occupation RFE question. This is the very basis on which a H-1B can get approved or denied, because in order to file a H1, you cannot, not every job qualifies for a H1. It has to be a job that requires a bachelor's degree in a specific field. So, for example, if I file a job that requires a bachelor's degree in business administration, or a bachelor's degree in arts, or a bachelor's degree in engineering without specifying which field of engineering, then you're not going to get an approval for that case because it is not a specific field. Now, say I file a H1 where, say, a nurse H1, because we have a lot of problems with those nurse H1s. Nurses can, work even with an associate's degree in most instances. They look at industry standards. And even the licensing, in order to get a nurse license, you need an associate's degree. Most states don't require a bachelor's degree, though some do. So for those states which require a bachelor's degree, you have no problem getting the H1 approved. But in most instances, only an associate's degree is required. So, avoid those kind of jobs. If you're filing a H1 for those kind of jobs, know at least that it won't be approved. And if you still have to file, then you have to show how your employer is different, how your company is different, and why they need a bachelor's degree when other people don't. So you don't meet the industry standards, but you can show that the job is so complex, uh, and so sophisticated that and differentiated from how your job is different from other jobs of the same job title. And and then you can show maybe that your employer is different because they have more volume, or they have different clients that require the same title, but the job is such that a bachelor's degree is required. For example, um, say a civil engineer kind of position. We know that all civil engineers require a degree because that's industry standard. But within the civil engineering industry, an estimate engineer, person who does estimations of project estimator. You know, some H1s get approved and some don't. In general, you don't require a bachelor's degree, but you can show that your estimations have to be so accurate and done so much in advance that a bachelor's degree is required. A person with a background in that field in finance is required to do your estimations because you have government contracts. And in order to get the contract, you need to do an estimation first, and you can't be off on the estimation because then you lose money, right? So these are some ways in which you show that a bachelor's degree is required. So the other ways of showing it is, of course, showing going to dice, going to monster, showing that the position most often, if not always, requires a bachelor's degree. You can also show that your employer, uh, you as a company have hired people only with a degree in computer science for that particular position. And you can show W-2s, you can show their degree copies, etc., in order to prove that. You can also get an expert opinion from a professor saying that, okay, these are the job descriptions, I've evaluated them, I've evaluated the beneficiaries' educational qualifications, and I think that the position requires a bachelor's degree in a specific field, and this is why I think that. So these are some ways of, overcoming those specialty occupation RFEs.
Thank you so much, Prashanti, for highlighting them. And I think, we should address some of our viewers' questions right now. So let's take up this first one from Pratibha. This is on YouTube. Pratibha is asking, in the RFE, they've asked for more evidence about my employer's ability to pay the prevailing wage. What kind of financial documents can we submit to address this concern?
Is this the I-140? Is this an RFE for an I-140 or a H-1? I'm
My
interested to
employer's
know
ability
that.
to
So can you
prevailing wage for, yeah.
can you just let us know? And if you don't, then we'll just answer both ways. But I'm hoping she'll get back to us as to, is it a I-140 or
Okay,
a H-1
Pratibha,
that she's talking?
it's for an I-140.
Oh, good. Okay. So, and that's what I thought, but I just wanted to make sure. So, if you're getting an I-140 RFE, which we didn't really cover, and I'm glad you asked that, most often than not, the RFEs will be about ability to pay, and the ability to pay the prevailing wage. And if you're already getting paid the prevailing wage, then you don't really have to show much. You just have to show your W-2s to show that you're already getting the prevailing wage. If, say, you're getting if the prevailing wage is 140,000 and you're getting 120,000, but you are 20,000 off, then you can show one of two things. You can um, ask for the employer to submit their tax returns. The employer will then submit their tax returns, and they will show the ability to pay the remaining 20,000 either through profits, that is taxable income. If they have 20,000 or more, then they can show that. Or through net current assets. If they are filing based on a cash basis, then they go to the Schedule L, they deduct the current liabilities, and you get net current assets. And if that's 20,000 or more, then that's sufficient also to show ability to pay. So those are the two things that they usually look at, plus the salary that is already being paid.
Okay, so Pratibha, there you have your answer. And if you have more questions, you can keep commenting. We'll be happy to address them. Thank you, Prashanti, for the detailed answer.
You're
Now
welcome.
I have Anjali. Anjali is asking, I received an RFE for my H-1B petition, and I'm really confused about why it was issued. Can you walk me through the most common reasons why RFEs are triggered for H-1B petitions? Well, Anjali, we really covered this at length in the beginning itself. I think probably when you just commented, we were still going through that. So, not to worry, you can always rewatch this whole webinar. So, yes, thank you for your question, though. Thank you for participating. And we have Dheeraj now, Dheeraj Reddy asking, I'm currently on H-1B effective from October 1st, 2024, and I got a new and better opportunity and I would like to transfer to the new company, and I don't have any pay stubs to show to the new company. My first payroll will run on December 10th. Could you please suggest will there be any complexities if I transfer now?
You're better off transferring after December 10th, but you might be able to file now and you won't get an RFE until December 10th. So if you're not doing in premium processing, or even if you do, you have plenty of time to respond. So by then you might get your payroll, so you might be okay.
He had mentioned about himself earlier saying that I have sent my RFE response for STEM approval to USCIS. Oh, sorry, this is another one. So let's take this up. This is Durga Rao. I'm so sorry. I'm so sorry.
No problem.
So Durga Rao has a question too, asking, I have sent my RFE response for STEM approval to USCIS. It is reflecting as received on portal. How long it takes to get an update? And in this scenario, where if it gets denied, what all options does he have?
Um, if you're denied your STEM OPT, so we're talking about STEM OPT, and if he's denied that, then um, uh, you have you have to see then if you have it the 60 days. You have 60 days grace to file for your STEM OPT. So if you're within that 60 days grace, then you can file again, or you can file, go back to school, or you can file for a change of status. But if you're outside the grace period, then there's not much that you can really do. And I know a lot of students last couple of years have been getting RFEs on their STEM OPT extensions because either they haven't filed it properly, or they haven't submitted the documents that they should, or the DSO has made a mistake when submitting documents. So many things happen, and they lose the opportunity of then even ever being able to work. I mean, being able to work on that STEM OPT, so getting an extension. So yeah, that's a problem. I recently had a client call me, and the reason for her STEM OPT to get denied, there was an RFE, was that the E-Verify number was wrong, and they sent a RFE saying E-Verify is wrong, but the employer insisted that it was the correct E-Verify. So then they ultimately denied it, saying, sorry, this E-Verify doesn't belong to this employer. It belongs to another company. So, and it got denied. So a lot of these things are happening, and unfortunately, students are suffering because then they have to forego the opportunity of getting a STEM OPT extension, right? So they might already be on, have a job, they'll have to give up their job and maybe go back to school if they're able to, or even in some instances leave their country if they're not, within that period where they can change status.
Thank you so much, Prashanti, for taking that up. And Durga Rao, I hope you got your answer. Now let's take up Suraj. This is also on YouTube. Suraj is asking, what precise documents and information should we provide to convincingly establish the employer employee relationship and satisfy USCIS requirements? Our H-1B petition received an RFE questioning the employer employee relationship, specifically requesting evidence.
Oh, interesting. So, Rich, I'm
Okay.
surprised because USCIS is not supposed to be asking for employer-employee relationship. If I was your attorney, I would send them the memo, send them the court decision. They're not supposed to be asking for employer-employee relationship. So you should not be
Interesting.
responding to how we used to respond earlier with the right to control documents, etc. You shouldn't be doing that. You should remind them that there is no. Um, I mean, the fact that you're on their payroll is sufficient. So you should, to that extent,
Mhm.
say that yes, I'm on their payroll. They're supervising me, but you don't have to give too many details. Instead, I would submit the memo.
Okay. Very
The
interesting. This is.
USCIS issued a memo based on a settlement agreement that they had to
Mhm.
come to because of a court decision. So, as a result of
Okay.
the court decision, they came to an agreement that they will not ask for employer-employee relationship beyond what is normal. I mean, they were taking it to such an extent that it had become an abnormal you know definition of what an employer is. An employer is basically a person who is paying your salary and who
Mhm.
is in charge of hiring or firing you. They have the right to hire and fire and pay your salary and nothing beyond that, but they were taking it to a greater extent than that. So I you should definitely do your research. If you have an attorney, I'm sure they're aware of it, but yeah, submit the memo and the court decision. That will act in your favor.
Okay. Thank you so much, Suraj, for your question, and thank you, Prashanti, for taking that up. Very interesting question, Suraj. And so, yes, if you in fact want to have a one-on-one consultation with Attorney Prashanti Reddy, why not contact her? Her details are on the screen. You can call her on this number, 212-354-1010. You can also email Prashanti at reddyesq.com, and go visit www.reddyesq.com to get to know more about Prashanti Reddy and the law offices of Prashanti Reddy. Now we got Neha on YouTube. This is another question asking, hi, I got RFE on education evaluation for my I-129 non-immigrant on October 31st. Can you elaborate how the attorney work for the particular RFE? How long does USCIS take to decide?
How the attorney work? What does that mean? What is the attorney's role? Or
Elaborate how
um,
the attorney work for the particular RFE. Yeah,
so,
I think.
guys, you need to yeah, maybe attorney's role, but please, when you're typing your question, don't be in a rush to type it. Type it with all the information that you need to get. Word it properly, so I'm not left guessing as to what is the question. And type all the words in properly. When we type in words, sometimes we do the short forms, and sometimes it's not
I know.
difficult to understand. So
Yes, great question.
I, well, the attorney's role is obviously to respond to the RFE, but the attorney will also
Mhm.
then get seek the help of outside educational evaluation company, and they will get the educational evaluation done. Usually it can take 2 to 3 days to a week to get it done. I'm sure they have express services as well. And the evaluating company will use a professor, or they will use a qualified evaluator to give an evaluation to show that the person has the equivalent of a bachelor's degree in the US in that particular field. And usually the evaluator will include their resume, they have to, and they'll include a letter from the school saying that they have the authority. They do this in their school as well. So,
Mhm.
yeah, that's how, and then we include that evaluation, we include any other documentation that they're asking for. We include the degree copies, all the mark sheets, the transcripts, and we are careful to make sure that we include try to include the original, in the sense that not the provisional degree, but the original copy of the original degree, and all the transcripts. In an evaluation, you have to make sure in these kind of RFEs that you include all everything that's required.
That's right. Thank you so much, Neha, for your question, and I hope that that was pretty clear. If you have any further questions, you can always comment, and we will take them up. Thank you so much, Prashanti, for taking that up. Now we
Mhm.
have Trisha. Let's take up Trisha's question. Just wanted to know, can we appeal or reconsider an RFE decision if we believe USCIS misinterpreted our evidence or made an error in their assessment?
Absolutely, and I'm glad you asked because we didn't cover motion to reopen and appeals. So if an RFE gets denied, you have another chance of having someone look at it. You have to file within 30 days, either a motion to reopen, and you have to pay a fee of 600 odd dollars. If you're filing a motion to reopen, then you're filing it back with USCIS, and then they're going to take a second look at it. So most probably a supervisor will look at it. Or you can file an appeal, which is a better option. Then the appeal is actually filed with the Administrative Appeals Office. So this is a completely different body that will look at the documentation that you submitted, and most often than not, they don't overturn decisions, but sometimes they do, especially if there's a clear error in the USCIS decision. And the good thing about an appeal is it first is acted upon as a motion to reopen. Supervisor looks at it anyway, and then if they think that they want to stick to their decision, then they send it to the appeals office. So that's how an appeal works. The only disadvantage of a motion to reopen or an appeal is that they don't have like a definite time frame within which that they respond. Sometimes it takes 6 months,
Mhm.
sometimes it takes longer. So we're kind of left hanging, in a state of limbo for that period of time. But in some
Yes.
instances, it just makes more sense to refile if you're already in status. In some
Mhm.
instances, if you're not in status anymore, then the appeal is the only way that you can move forward. And sometimes it makes sense to do an appeal simply to get some time, because as long as your appeal is pending, you can still remain in the country. So if you're still not sure about what your next step is, you can file an appeal and gain some time as well.
Okay. Okay, thank you so much, Prashanti, for taking that up for Trisha. And I think we have addressed most of our live viewers' questions so far. But I have a few more questions from our groups and our YouTube comments. So I think I will just open this, share the screen with you. Let's take up this one from YouTube, from our YouTube channel first. This was from Malu Tech USA. Indians on H-1B will get green card faster, but Trump will make regulations to stop replacing Americans with H-1B visa employees to making by making wages of foreign employees equal to US citizens. What do you have to say to that, Prashanti?
Yes, that is true. And that is what the new administration, I think, intends to do.
Mhm.
um, their rules aimed at raising minimum pay for H-1B visas. And in fact, under the previous Trump administration in 2020, Department of Labor published a rule aimed at basically at pricing high skilled foreign nationals out of the labor market, pretty much. So the Department of Labor, the way they did it is they changed the prevailing wage, and the rule kind of forced companies to pay 40% to 100% more than they would pay US born professionals. So if you're on a H1, you would pay 40 to 100% more than you would pay a person who's a US citizen. So didn't make any sense. So, for example, the minimum wage for um, over 18,000 jobs was 208,000. So and we're talking about even entry level positions, right? So,
Mhm.
which effectively, this is a way for them to effectively stop H-1Bs. And luckily, the rule was not passed because it was passed as an interim rule, and the court said that it went to court, and the court said that there was no urgency in this, and there was no reason why they couldn't publish it as a proper, after giving notice, publish it as a permanent rule. And that's why it didn't come through. And then, of course, the administration changed. But so they're going to attempt to do it again, for sure.
Mhm. Well, there you go, Mallu Tech. Thank you so much, Prashanti, for taking that up and for the detailed answer. So now I have another question. This is also on our YouTube. This is from Srinivas asking, He could overhaul the H-1B system based on merit points based system and a path towards the green card. Remove the lottery based system. Why are you not considering it? Even if he has to go to Congress and change laws. He's talking about Trump.
Uh, Overall, overhaul the H-1B systems based on merit. Remove lottery system. Why is he not constrained, even if he has to go to? Because he doesn't want to. I mean, it's very simple. uh, the present Republican government is anti-immigration. I mean, I don't know uh, why that is not clear. Um, and it's not just illegal immigration; it is legal immigration as well. Just look at their track record um, when during his last administration, right?
Mhm.
And look at the people who are making his policies, Steve Bannon. So, I mean, I don't know why people are in denial, and I hope I am wrong, but there is an anti-immigrant sentiment all over the world, and in the US
Mhm.
as well. And if you look at the denial rates if you look at the denial rates during the last Trump administration, it was uh, it went from 6% to 24%. This is H-1B denials.
Huge. Huge.
Yeah, yeah. And then after when the Biden administration came in, it was 2.2%. So from 4% previously, from the previous Democratic government. So you see, I mean, it's quite clear. I mean, there's no ambiguity here. Um, and the RFE rate was 60%
Mhm.
in during the previous administration, and now it's 10% or less. And this is not something that anyone is making up. These are actual facts from that are gathered from the from USCIS. So I don't know
Mhm.
why people are still in denial that the Trump administration will do something better. I mean, I don't think they
Mhm.
will. I really hope they do, and I hope I'm wrong. I'll be the most happiest person.
Well, let's see. Let's wait and watch what have we got for, I mean, starting 2025.
If he changes his mind
And
and they've changed their mind about how they want to approach immigration, that is certainly possible. But will they do it after everything that they've said and done? I don't know. Then they won't
mhm,
have their voter base, right? That they had because they're going
yes.
against their election promises. So,
Mhm. Well, I have this next question, Prashanti. This is from, Facebook. This is Anil Sharma saying, Hi, recently my H-1B got stamped and I want to process H-4. Can you please tell me the process for H-4 for the first time? Is I-797 required for H-4? If yes, who will file an employer? Who will file? An employer or me? Currently, I'm in India.
if you're presently in India and your spouse is on a H1 and you're trying to come on a H4, then you have to go get
Mhm.
your H4 visa stamped in your passport. And that's the way that you come in on a H4. You don't require I-797 for a H4. You take your
Okay.
spouse's I-797 and your spouse's pay stubs and uh, proof that he's presently on a H1. That's the pay stubs that he's presently
Mhm.
getting paid, and take the proof of relationship, the marriage certificate, and go to the consulate. That's the easiest visa to get, the dependent visas.
Okay. Thank you so much, Prashanti, for taking that up. This is Anil Sharma's question. Now we have another question, and I do not know why is it not loading. But meanwhile, we can address this one. In the last term by President Trump, he had restricted a lot of H-1B visa extensions during his term between 2016 to 2020. Will he be doing the same, and what kind of restriction he might be implementing during this presidency period? Period also. Can we expect fast process towards I-140 visa approvals? Prashanti?
we can't expect anything good. So if you're expecting anything that is good, you might be disappointed. Um, there's a lot that I mean. This is what is expected is that the Biden administration um, published a proposed rule in 2023 last year on
Mm-hmm.
modernizing H-1B requirements, and they implemented part of it with reference to the registration process that you can't file, that they will only consider one registration. Um,
Mm-hmm.
and but there are other parts to it which they have not yet implemented, and I hope that they will implement it before the end of the year, but I don't know what is involved and how long it will take. But if they don't, then what the present administration will do is implement their own version of it. They'll just um, take their own. They'll make changes to what has been published, and then they will finalize it, and they will implement a much
Mm-hmm.
stricter version of what is already in place. Um, there are
Right.
a lot of things in place which are good and which are also restrictive, but there's a lot of good stuff also in there. One is allowing self-employment, so allowing people to file their own H1s and work for
Mm-hmm.
themselves in some situations. Um, giving difference to previously issued approvals. So if you've previously been on a H1, it should be much easier for you to file an H1 extension or a transfer if the facts have not changed. Um, also, occupation, they're as they're related. This is what we were talking about with reference to specialty occupation. So they're broadening it. What is the definition of specialty occupation? They're also
Mm-hmm.
giving some benefits to F1 students for cap gap. So their status doesn't expire on October 1st. It'll continue until
Mm-hmm.
August, for example. Um, so
Right.
this all this will go away, and then it'll be much more restrictive. As I said, there'll be an increase in the number of denials and the denial rate and the RFE rate. Eligibility will be changed. As I said, they might narrow the specialty occupation definition again. We talked already about higher salary requirements. Um, Another important issue is spouse work authorization.
Mm-hmm.
The Trump administration actually put in put in their regulatory agenda. Every government has a regulatory agenda that what they intend to do. They put in employment authorization for spouses. They didn't actually get to it. They didn't have time to do it, and there was also lawsuits back and forth, pro and against. But then the new government came in, and
Mm-hmm.
then they didn't pursue those lawsuits. Um, Also, the Biden administration put in a biometrics requirement for H4 dependents. And because of that, H4s were not being processed with H1s. And there was recently a court case where they reached a settlement where H4s and H1s would be processed together. But that settlement is
Okay.
expiring next year, and it's very unlikely that the Trump administration is going to extend it. Uh,
Mm-hmm.
so then you will end up again. The same thing will happen even if he doesn't remove H4's work authorization. It'll take 18 months for the H4 work authorization to get approved. And that's as good as not having it. And that's what happened under the last administration also. Um,
Mm-hmm.
Worksite limitations, so making it tougher to work under third party client sites, maybe reintroducing employer-employee rules, reintroducing the requirement for detailed contracts, work orders, etc., etc. So all that might happen. There might be some counterbalances. Counterbalances could be litigation, so courts will be very active during this time. But I'm worried that the court demographic has also changed.
Mm-hmm.
Maybe people like Elon Musk and others that are supporting Trump's are pro legal immigration, so they might have a say. I don't know to what extent, and to what extent they
Mm-hmm.
will put their necks out to see that this happens. Maybe they'll just remain quiet. Who knows? So these are all the things that we don't know about, but all the things that are we should be thinking about.
Right. Thank you so much, Prashanti, for addressing that. And I have a couple more. But before we move on to those, I wanted to take up this question from Rag on YouTube. Rag, thank you so much for joining us. And it's really nice to have you join us once again. And his question is: the outpouring advice currently is to rush and file before Trump takes office. Will this take a toll on the petition outcomes? And should we rush, or will a cautious approach work?
I definitely agree with that, and I didn't say that so far in this program, but um, I was attending an ALA conference, a roundtable conference yesterday on business
Mhm.
immigration, and really all the attorneys are saying the same thing. They're advising their clients to file H1s immediately, file premium processing, file whatever petitions that they have to file. If they know they have to file it anyway, why don't you file it now instead of filing it next year, right? Because you know
Mhm.
that even may not be from day one, but at some point, or even maybe from day one, who knows? If they issue an executive order on day one, buy America, whatever, hire America, Baja, um, like they did
Mhm.
last year, that would automatically change that is giving instructions to USCIS officers on how they should adjudicate cases, and they will start adjudicating them more strictly. And so there doesn't have to be any change in law; it's just a change in their policy. So I would definitely advise those who are planning to file extensions, transfers, who need to do it this year rather than doing it next year. If you need to go for a visa, also, I would suggest go if you can get a visa appointment, do it sooner rather than later. Also, I
Mhm.
would advise on travel. If you need to travel, do it this year. I mean, I'm not saying don't travel at all because you have to travel, right? But maybe you can wait until the dust settles and then travel next year rather than, so I would suggest travel this year rather than next year, um, if you have to, right? So, yes, absolutely. Do whatever you need to do this year while you know what to expect, at least you know what to expect.
Right,
And
right.
not only
Thank you
file,
so much, Rag.
not
Yeah.
just filing it, file it premium processing, because if there is a decision that's pending until next year, then you are again subject to the policies of next year or next administration.
Right. The faster, the better it is then. So,
Correct.
Rag, thank you so much for your question, and thank you, Prashanti, for taking it up.
You're
If
welcome.
you have some more time, we can take a couple more questions if it's fine.
Yeah.
Okay. So this is from Shakti asking, "Hello, all. I got an RFE for initial OPT. Any attorney help me with all the 8 points? It will be so helpful for me." Now, what is this 8 points he's talking about?
I think maybe he just is looking for an attorney.
Yes, and if you are, I think you can always consult Attorney Prashanti Reddy, and you can call her up on her number 212-354-1010. You can also email Prashanti. Her email address is prashanti@reddyesq.com, and she'll be really happy to help you and get to know your case better. So thank you, Prashanti. And moving on, I have this next one. This is from 3 Vikram. Hi all, I'm on H-1B and working as a contractor. My spouse is on H-4 EAD and she is working for another client as FTE. My current client has offered me the FTE role. If I switch to a new employer, will it impact my spouse's visa status? Please let me know.
New role. New employer. I mean, I was wondering what FT is, but I realized it's full-time employment. Um,
Mhm.
okay. So if I switch to a new employer, will it impact my spouse's visa? I mean, no, as long as you're on a H1, your spouse does not have to file a H4 every time you file a H1. Your
Mhm.
spouse only files a H4 or H4 EAD when it expires.
Okay. Thank you. Thank you for taking that up for Trivikram, Prashanti. For some reason, my other pages are not loading. So I think we will, that's it for, the audience questions for now and questions from groups. So we could wrap up today's session, but before we leave, maybe you could also tell us, especially with, um, Indians securing. All right, let's if you could just tell us about this level one wages. An employer sponsoring an H-1B worker receives an RFE related to level one wages for a specialized IT role. What documentation or arguments can they present to justify their wage levels?
Again, a great question because we didn't cover that. This is another reason why you might get an RFE. Again, this is also a good example of how um, policy changes when
Mhm.
administrations change. This was a big issue under the Trump administration. They were not they were sending RFEs and even denials for level one wages, even though the position was actually level one. So we were advising all our clients to do level two and not do a level one, even if they're entry level. But I mean, absolutely, you can do a level one wage in the presently they are approving cases, but you have to make sure that you're not filing a level one wage because you like the salary, but you're filing it the job is actually a level position. And it's not a person who has 10 years of experience and you're filing level one because you want to pay them a low salary. So the way that they look at um, whether it's an entry level or not is how many years of experience is required for the job and what skills are required for the job. So they have a table and they have a point system. So if you count the number of points, everything has a point. So if it requires more than 2 years of experience, then 1 point is added. If you have skill sets that are required, another point is added. So that's how you go from level one to maybe level two, etc. And that's how it's done.
Okay. Thank you so much, Prashanti, for addressing that. And I think with this, we can wrap up our discussion for today. We spoke a lot about H-1B RFEs and, what triggers these RFEs and how can you successfully respond to these RFEs. Thank you so much. But of course, there are so many, many different kinds of them, and each case is different. Each RFE could be different from one another. So thank you so much, Prashanti, for helping us dive deeper into H-1B RFEs today. And I wish we could go on and on with this discussion because from what it seems, it's going to be endless, at least for another couple of hours.
Yes.
Thank you so much, Prashanti. I hope we can discuss this again, maybe in the coming episode in the coming week or so. But thank you so much for doing this today. It was great to have you. And yes, if you have any end note before we want to leave, you could leave our audience with what you want to say.
I think we've said a lot, but it's always better to be cautious. And I mean, take the worst case scenario approach, and file your
Yes.
petitions as carefully as possible. And if that doesn't happen, that's great. But at least you'll be prepared.
Right. So I think I can say all the best, but always be prepared for the worst as well. Anything can happen. So thank you so much, Prashanti, and have a great day ahead. I'll see you soon.
Thank you. Bye bye.
Bye-bye. Thank you, friends. Thank you for, participating in our webinar with your questions and your comments. And if you are watching this after the stream has ended, please feel free to keep commenting because we have our experts who would love to address your questions. And thank you so much for joining in today here on Immigration and Jobs Talk Show. Don't forget to like our content and also share it with your friends and folks who would benefit with this kind of content. And do not forget to hit the bell icon, so that whenever we have discussions like these, you are also notified. You can share these discussions and also be a part of it by commenting. So thank you. And yeah, stay tuned to Immigration and Jobs Talk Show because we have more discussions, more webinars, more content coming up. And of course, the 4 p.m. show called The Daily Dose with my co host, none other than Sam. So tune in later at 4 p.m. Eastern Time. We'll be here to discuss more. Thank you so much for joining us. It's Nipasa saying bye for now.